has direct control over. Just as governments have been acquiring lands since the inception of our republic, every government, without exception, has granted some of these public lands to private entities for various developmental purposes. Unfortunately, some people have packaged some of these lands, which were granted to private developers decades ago, and presented them as evidence of what they have termed, quote, state capture, end quote. The ministry has had to issue press statements to correct some of these misinformations. However, given that this platform has a wider reach and audience, it is important to reiterate some of these issues, which we have already issued statements on, amongst others. One of such lands is the land which hosted the Bulgarian embassy. This land forms part of a larger parcel of land acquired by the state in 1920 by a certificate of title dated 6 July 1920. The land was, however, granted to one Theophilus Kofi Leighton as far back as 1977 for a term of 99 years, commencing from 1st April 1974. This lease will expire in the year 2073. Until then, government has no direct control whatsoever over the use of this land. After building on the land, the said Mr. Leighton entered into a private contract with the Bulgarian embassy and rented a house to the embassy for a short-term period before granting them a 50-year sublease. However, by a letter dated 5th November 1990, the then Ministry of Foreign Affairs declared the sublease to the Bulgarian embassy as void. Events following this declaration resulted in a series of litigations, some of which are still pending in our law courts. According to the sole inquirer appointed to investigate the demolition of the building, it was demolished by one Jojo Hagan, said to be the executor of the will of Mr. Leighton, pursuant to a court order. As previously stated, the government of Ghana played no role in the transaction whatsoever between Mr. Leighton and the Bulgarian embassy, nor was it a party to the contract or the demolition exercise. Government, however, decided to intervene in the matter due to the involvement of the Bulgarian embassy, which is an accredited diplomatic mission in the country. The Ministry of Lands and Natural Resources and the Ministry of Foreign Affairs and Regional Integration have engaged the parties involved extensively and have agreed on some compensation for the Bulgarian embassy, which will be paid by those who undertook the demolition exercise. For the avoidance of doubt, ladies and gentlemen, this compensation will not be paid by the Akufo-Addo government. Government will, however, continue to engage the parties until the matter is fully resolved. How is this evidence of state capture? Then there is the issue of land belonging to the prison service at Roman Ridge, which was leased as far back as 2005, and which matter has gone to court, and the court has delivered judgment on the matter. What is the role of the Akufo-Addo government in the land granted to a private developer as far back as 2005? Ladies and gentlemen, how is this evidence of state capture? Another allegation that has been made as evidence of state capture by the Akufo-Addo government is the Parks and Gardens land at Cantonment. This land was acquired in 1894 and granted to the predecessor of the Department of Parks and Gardens in 1952. The land was, however, leased to a company named Wuntirin Company Limited on 29th November 2016, long before the current government came to power. And those who were in power when the land was sold in 2016 have turned around to falsely accuse the Akufo-Addo government of selling this parcel of land. Indeed, the lease was made pursuant to a request from the then Ministry of Local Government and Rural Development, dated 16th August 2012, under the hand of its then Deputy Minister, Honorable Elvis Afriye Ankara, to sell 2 acres of the land, quote, to enable the Parks and Gardens raise the needed funding to resource itself, end quote. According to the then Deputy Minister, he stated further, and I quote, proceeds from the sale shall be used to provide parks and gardens with a new office, staff bars, sun tractors, water tankers, and the needed hand tools it is currently in dire need of to restructure and reposition itself as a viable government agency, end quote. And yet, even though the land was sold in 2016, in accordance with the minister's request, we haven't seen the new office complex of the parks and gardens, the water tankers, the tractors, and all the other things that the proceeds of the sale were supposed to be used for. Again, there are allegations that this government has sold some bungalows belonging to the judicial service in cantonments to a private developer. These bungalows in question were, however, sold as far back as 13th July 2015 to a company named Frames Oil Company Limited, following an approval granted by the then Minister for Lands and Natural Resources, Honorable Nii Osa Mills, on 2nd June 2015. Is it therefore not surprising, ladies and gentlemen, that the very people who supervise the sale of this property to Frames Oil Company Limited will turn around and accuse the Akufo-Addo government of state capture? For the Du Bois Center, as we have explained in the press release of 16 July 2024, the Lands Commission, the manager of public lands, and the repository of records of land transactions has no pending application for the transfer of this land. For the avoidance of doubt, the land in question, as we speak, remains in the name of the Du Bois Center. That land has not been sold. Ladies and gentlemen, the above examples clearly shows that the allegations of state capture and the narrative that this government is indiscriminately selling public lands are all palpably false, without merit, and obviously actuated by political considerations, given the heated political season we find ourselves. Indeed, the evidence shows that the Akufo-Addo government has been meticulous in protecting public lands in the public interest. On 17 August 2021, with the approval of the President of the Republic, a policy directive was issued to the Lands Commission, pursuant to Article 2582 of the National Constitution, to, and I quote, refer all transactions relating to the grant of any interest in public lands to the office of the Minister for prior approval, end quote. This was to ensure that the President, in whom these lands are vested, discharges his constitutional duty in an informed manner. The directive further stated, and I quote, any deed executed without the approval of the President through the Minister for Lands and Natural Resources will be deemed void, as same will have been done without the authority of the President in whom these lands are vested, end quote. In Northern Region, for example, the Regional Lands Commission has been directed to reverse a number of leases over public lands granted to private development without the prior approval of the President in accordance with this policy directive. This followed a report of a three-member committee the ministry constituted to investigate allegations of transfer of public lands in the region. This is a testament to our unwavering commitment to protect public lands in the public interest. Apart from the above directive to the Lands Commission, a series of letters and correspondence have been written to all public institutions to utilize public lands granted them for the purposes for which they were granted only, and not to create any third-party interest in such lands without the express written approval of the President given through his minister responsible for lands. Just a couple of weeks ago, Cabinet issued further directives to all public bodies, public institutions, and public corporations, including public universities, not to lease, sublet, assign, transfer, dispose of, or otherwise create any third-party interest in any public land granted or allocated them without the prior written approval of the President of the Republic. This directive, which was subsequently published in the dailies on Thursday, August 8, 2024, applies to all public lands that have been granted to public institutions, whether by way of freehold, leasehold, or any other form of grant. The days of public institutions entering into public-private partnership agreements with public lands without the approval of the president are obviously over, and any person who enters into any transaction does so at his or her own risk. All these measures have been put in place to ensure the protection of public lands and to regulate their utilization, ultimately in the public interest. Aside these preventative measures, pursuant to Section 236 of the Lands Act 2020, Act 1036, which enjoins the state to take steps to recover encroached public lands, the ministry constituted a public lands protection team to work with the Lands Commission to protect public lands from encroachment and recover those that have already been encroached. The team, in collaboration with the Lands Commission and the Ghana Police Service, has undertaken a number of operations to recover encroached public lands. The Commission is also working with the Ghana Police Service to provide protection for all public lands and departments and agencies, as well as metropolitan, municipal and district assemblies, to take steps to protect lands acquired for their use or which fall within their jurisdiction of the assemblies in accordance with Section 236 of Act 1036. Honorable Minister, distinguished guests, ladies and gentlemen, there is also the issue of the state returning lands to pre-acquisition owners. Let me use this opportunity to respectfully make a very important distinction between Article 26 of our national constitution, which requires that the state give pre-acquisition owners the first right to acquire compulsorily acquired land, when the state no longer has a need for the land, and instances where the state returns portions of compulsorily acquired lands to pre-acquisition owners in lieu of compensation or some other consideration. As the Supreme Court explained in the case of Obi Tetechuru III and Attorney General, 2010 Supreme Court of Ghana Law Report 904, Article 20 has a futuristic intention, and Act 125, the existing law before the coming into force of the Constitution, the state has always been enjoined to pay compensation for the acquisition of any land at all material times prior to the coming into force of the Constitution. Therefore, government was under an obligation to pay compensation for any land compulsorily acquired by the state. In some cases, however, no compensation was paid for the acquisition of these lands. When government receives a petition for the release of some of these lands, the petition is examined on its merits through a series of assessments, evaluations, and negotiations. Indeed, some of these petitions and negotiations transcend different governments. For example, in respect of the Kumasi Sector 18 lands, the Cabinet of President John Dramani Mahama first approved the redevelopment scheme on 1st September 2016 and authorized the return of 50% of the land affected by the redevelopment to the Golden Stool in lieu of compensation, which culminated in the publication of the state lands Kumasi Sector 18 Redevelopment Project Instrument 2021 EI 432. Suffice to say, ladies and gentlemen, that this is not the first time government has released lands to pre-acquisition owners. By EI 8 of 204, government released some 360 acres of Nungua Otinshi lands acquired in 1978 for the Center for Scientific and Industrial Research to the pre-acquisition owners. By EI 15 of 209, government released 99 acres of the Adentan land acquired in 1968 for West African Secondary School to the pre-acquisition owners. By EI 16 of 209, government released 114.055 acres of the Accra Mimpeasem land acquired in 1974 for the Accra Training College to the pre-acquisition owners. By a lease made in 2009, government released 974.53 acres of the Nungua land acquired in 1940 for livestock farm to the pre-acquisition owners. And by EI 17 of 8th November 2012, government released almost 250 acres of the Medina land acquired in 1977 for the Department of Social Welfare to the pre-acquisition owners. This list, obviously, is not exhaustive, but only seeks to demonstrate that it is not novel for government to release public lands to pre-acquisition owners for one reason or the other. What is important at all material times is the consideration whether or not it serves the public interest. Distinguished guests, while protecting existing public lands, government has also been acquiring additional lands to increase the public land estate of our country to meet our developmental needs, including the 13,230 acre land at Afienya, Dowenya for industrial enclave and urban development, the 509 acre land between Afienya and New Akradi for railway development, and the 237 acre land in Tamale for the University for Development Studies, among others, all acquired in 2018. Several schemes are being implemented in Kumasi Sector 18, which comprises of Rich, Danyame, and Nshiasu residential areas, Old Tamale Airport, and Cape Coast Ridge Sector 1, 2, and 3 residential areas. We are also aggressively pursuing a digitalization program to digitize the records, including legacy records, of the Lands Commission to promote expeditious land service delivery across the country. Since the introduction of the Enterprise Land Information System, the Lands Commission has been vigorous in ensuring seamless migration of manual operations onto the system. And today, selected services of the Commission, such as consolidated searches, stamp duty assessment and payment, plan approval, among others, can be done online from the comfort of your homes. The Commission, in collaboration with the Ghana Association of Bankers, has also introduced an online portal for banking institutions to access its services digitally from their offices. Additionally, the 6 new regional offices of the 6 new regions, namely Ahafo, Bono East, Northeast, Oti, Savannah, and Western North, operate fully digital as we speak today. And we are in the final stages of engaging a private partner to work with the Commission to deliver a holistic digitalization of land services, which will ensure that the Lands Commission and all its regional offices operate fully digital. Honorable Minister, friends from the media, distinguished guests, ladies and gentlemen, a lot has been done within this short period that the Akufo-Addo government has been in power. But today, the assurance I want to give you as the minister responsible for lands, which is evidence from the statistics we have put together, is that the public lands of our country are safe, and government is working to protect them while ensuring their judicious use. What is our ultimate and overarching consideration is always the public interest. The people who sold some of our public lands, which has resulted in some misunderstanding and litigation with some public institutions, have had a temerity to turn around to accuse this government of the very acts they perpetrated. Fortunately, the records are still intact, and we know who sold these lands, which have been repackaged as evidence of state capture. In the spirit of transparency, the President of the Republic, His Excellency Nana Addo Dankwa Akufo-Addo, has directed the compilation of a list of all public lands that have been transferred, leased, sublet, or sold since the inception of the Fourth Republic on 7 January 1993. A dedicated team of men and women at the Lands Commission are working to put together this list, the details of which will be made public once the exercise is complete, and the Ghanaian people will have the opportunity to scrutinize this list and make conclusions for themselves. Let me hasten to add that the grant of public lands for development in and of itself is not necessarily wrong. As population grows with competing needs for land, it becomes necessary to change the use of some of these lands to meet the developmental needs of the nation. For instance, the Labone and South Labone estates were originally acquired in 1902 for coconut cultivation, but had to be given to the State Housing Company to develop them into a residential area. The lands at Botema, which now hold the Botema Estate, Sports Complex, and Aquatic Center, were acquired for livestock farm in 1940. Airport residential area, as well as portions of Airport West and East Legon, were originally acquired for aerodrome services, but have been developed into one of the prime areas of our capital city. cantonments and switchback residential areas, parts of Roman Ridge, Jowulo, and Achimota residential area are just a few of such examples. Indeed, in the case of Obito Tichru, the third and Attorney General, Doche JSC, after citing some examples like the Accra Race Course land, which was converted for use at the Accra International Conference Center, and the Makola No. 2 Market, which was converted into a modern car park, concluded that, and I quote, "Once the use to which the land is to be put is not restricted to any personal or individual interest, but one to which the general public will have a benefit, or the benefit of the project will endure to the entire country either directly or indirectly, the public interest purpose will be deemed to have been adequately catered for," end quote. The overarching question all the time should thus be, what use was a particular land put to? Does it serve the public interest? Distinguished guests, ladies and gentlemen, as managers of public lands, we are not oblivious of our fiduciary duties to the people of Ghana, and under the able and outstanding leadership of President Akufo-Addo, we will continue to discharge these duties transparently, anchored on the highest standards of integrity, candor, and utmost good faith, to ensure the protection and judicious use of public lands in the public interest and for the ultimate benefit of the people of Ghana, the true owners of these lands. I am happy to report to the country that the public lands of Ghana are intact and secured under this current government. I thank you for your attention.
Thank you so much, Honorable Minister. I'm just excited about the clarity of expression and thoughts. I don't think there is anyone who would have any doubts that Ghana's lands are in safe hands after listening to you, Honorable Minister. It's not just about the presentation, but also the facts. You spoke about leases and you gave us dates. In this day and age and in the face of the implementation of right to information, it is as simple as filing a search and you will be able to get the facts as Lands Commission as to when any transactions on a particular land were undertaken. I am excited, Honorable Minister, also for the fact that we are digitalizing the land services in Ghana. It's one area that people have a lot of concerns. Even young people who have business interests or those who want to apply for residential purposes. It's not about having the money, but sometimes you are not sure if what you are procuring is supposed to be up for sale. So this digitalization will really bring so much relief to the public. Honorable Minister mentioned so many things, but most importantly, about the laws regarding expropriation.
Begin by saying that I'm very encouraged by the nature of the questions and how nuanced they are. I mean, that's how it should be. You observe that in every election cycle, this matter comes up. And I believe that this discussion should be an ongoing one, which is devoid of partisanship. But unfortunately, you have a situation where in 2008, we all remember the heightened agitations politically about public land, about garlands have been looted, and this and that. And 2009 to 2017, we didn't see any substantive response to those allegations. Here we are in 2024, where we are 3 months to an election, and that same effort is being made to creep up public sentiments against government. Public lands are being sold, garlands are being stolen and grabbed and looted. All of them are false, as you can tell. And as I say, I throw the challenge that anybody can step forward to tell me that, Mr. Minister, this garland is being sold, this particular land has been taken, this appointee has been allocated this land. At least since I'm the minister, I can put my hand in fire that nobody can bring any evidence to prove that. And the rule of this discourse its records, and its data. And the data is there at Lands Commission. If anybody has any contrary data, they can put it forward. And that is what I've done, to put out the data, to put out the records, to establish that those allegations are palpably false. They are only motivated by political considerations. And that's why I'm happy that you media people are asking the substantive question, the question that have to be addressed. The first question came from the journalist from City FM in Channel 1 about Achimota Forest. And I think Achimota Forest, I've given an update on it over and over again. When I'll repeat it, I'll reiterate it. You remember that I issued a 48-paragraph statement, the 25-page statement, which set out the entire history and the issues relating to Achimota Forest. And I did indicate that as far back as 5th September 2013, His Excellency President Mohammed's government granted cabinet approval for the return of some of this land to the old family. And at the time I became minister, 362 acres of the land had been concluded, leases had been given in respect of those lands. Some of them, decisions had been made that 362 of the Achimota Forest lands be returned to the old family for one consideration or the other. And that transcended from President Kufuor's government all the way to President Akufo-Addo's government up to 2021 when I became minister. We set up a team, we went into negotiations with Achimota Forest because we were concerned about the ecological integrity of the forest, and we wanted a buffer. We wanted a buffer between what the Achimota Forest, the old family will have, and what will now constitute today's Achimota Forest. And we were able to negotiate a reduction of 100 acres out of the 362 acres which had been cast in iron by previous government, and the current administration had been bound legally by previous governments for the release of 362 acres of the Achimota Forest. And so as we speak today, we've negotiated a reduction of 100 acres, and now the parcel of land that is supposed to be released back to the old family is 262 acres. Now let me also make the point that we structured the arrangement in such a way that even for an individual or anybody to take possession of the land, given the ecological sensitivity of the forest reserve, we put in place stringent condition precedent that one has to satisfy before the person can take possession of the land. And so as I speak today, even though this transaction has been concluded a year or so ago, nobody is taking possession of even a square meter of Achimota Forest land or a square meter of the land that has been given to the old family, because we are required to go through a very laborious process to satisfy us that, for example, we are not going to take the land and build a factory which will compromise the ecological integrity of the forest reserve as currently constituted. So it is still work in progress, and people have applied to take possession of portions of the land. They are going through the process. They have to go through EPA, they have to go through LUSPA, they have to go through the Assembly, they have to go through Forestry Commission. So it is detailed, and that's the update I can give you. There's a question on the withdrawal of lease by the Judicial Service land. So this is what happened. The land was sold in 2016, and with the greatest of respect and in all humility and modesty, I'm a lawyer, and I believe that the lawyers will appreciate it. For the purposes of the law, the land is sold when the lease is executed. When you have a lease between the president of Ghana, which is normally the way the lease is structured, acting through the chairperson of the Lands Commission, and the lessee, and the lease is executed, the land is sold. So the semantics about a lease was withdrawn and investigations were conducted and the rest, I don't buy any of those semantics. The land was sold in 2016. When the new government came into office under Minister Amewu wanted to satisfy himself as to about the processes leading to the grant of the lease. And so he asked the Lands Commission to hold on with further processes. And there can be further processes as in applying for title and so on and so forth. So he asked that they hold on with the further processes until he satisfied himself with the facts which led to the lease of this land. And of course, the minister was right to do so, because this was land which belongs to the judiciary. And if land which belongs to the judiciary has been leased, it is just right that the minister takes informed decisions. And after the minister's investigation, he came to the conclusion that the lease is unimpeachable and that there's little or nothing that he can do about the lease. In any event, if the minister had come to the conclusion that the grant of the lease was wrongly done, or that he wanted to cancel the lease and the rest, the lessee had the right to sue. The lessee would have had recourse in the courts of our country. And so, for my purposes, the allegation was that the judicial service lands were sold under this government of President Akufo-Addo, and that is evidence of state capture. And when these allegations are made, my attitude is very simple: put together the records, assemble the facts before we make any decision. When the facts were assembled, it turned out that the land was not sold under President Akufo-Addo. On the contrary, the land was sold under President Mahama in 2016. So that's really what it is there. Ghanaian Times wants the definite timeline for the compilation of the I just consulted the Executive Secretary, and the Executive Secretary is of the view that substantial work is being done. As you know, the Lands Commission it fundamentally still operates manually, even though there is some digitization, and this is compilation across the country, and the Lands Commission is a decentralized institution. So it takes a bit of time. It takes time and effort to be able to put all of this together. But I'm very comforted and encouraged that the Executive Secretary is giving the indication and assurance that substantial work is being done, and therefore, sooner rather than later, we will complete the exercise and we'll put out the information for the scrutiny of the Ghanaian people. It may be that at some stage we may want to even just put out what we have so far while the work is completed. And then there's a question from the question about, will government retrieve the land? Will we give a directive to retrieve the public land? I mean, if they were granted wrongly, or we think that the grant is fraught with fraud or impropriety or whatever, why not? We will take steps to retrieve them. But always remember, when it comes to land transaction, they are steeped in law. So when you go, you have a lease, which is a contract with the parties, and is governed by law. It is not that straightforward to be able to cancel a lease or withdraw a lease. But if there's a need for it, we will take those steps. I can give you that assurance. There's a question about selling public lands to public appointees. Well, the rule of the game is evidence. I mean, if anybody has evidence that a public appointee has bought public land and is done so in a manner that offends the code of ethics of public officers, and that the person is put himself in a position of conflict of interest, why not? We will take a look at it. For myself, as a general rule, I do not think that public appointees should go anywhere near public lands. I think if you want land to buy, you should go and look for land in a private space and not public lands. Because of the very thin line of conflict of interest, it is very easy for you to cross that line. But if you have evidence that any public appointees bought land and is done so inappropriately, we will be happy to look into that. Then there's the question from CTFM about law and military, and that is a straightforward one. It's a long-standing issue which has transcended several governments. I inherited it. There were a lot of agitations at the time from the La youth, and also petitions from the La Traditional Council. I constituted a committee, a 5-member or so committee, with representation from the Ghana Armed Forces, from the La Traditional Council, from the Ministry, from the Lands Commission, that did thorough work, very, very detailed work, came up with their report. We've since granted a lease to the La Traditional Council, but the Ministry of Defense is engaging the La Traditional Council and the Ministry of Lands and Natural Resources for an arrangement which will ensure that the taking of possession of the land does not result into unnecessary controversy. As you know, whenever you are dealing with the military, you have to be sensitive. So we have to give them time and also accord them that space to be able to conclude this engagement. So it is still work in progress, but a lot of work has been done. I've been to the La Traditional Council multiple times to brief them. A lease has been granted in their favor. That has been done. That has been concluded. Government is fully committed to returning these lands to them, which is why we went as far as granting them the lease. But the Ghana Armed Forces has concerns or issues they have to deal with, and rightly so, because it's a very important, sensitive institution. And the Minister for Defense and the Chief of Defense Staff is taking very important steps to resolve the outstanding issues for us to have an amicable resolution of this matter. And I'll use this medium on opportunity to crave the indulgence of the youth to continue to exercise restraint and patience whilst we go through this very complex process of finding a resolution to this long-standing matter. There's a question from Daily Graphic about President Directive and then Cabinet Directive. So let me give you a distinction. The directive we gave earlier in 2021 was essentially directed at the Lands Commission, if you want, so that the Lands Commission was not to grant any public land without the prior written approval of the minister responsible for lands, acting on behalf of the president, who is the trustee for public lands. And there is a constitutional underpinnings to that. The president is the trustee of public lands, and therefore both myself and the Lands Commission, we are acting for and on behalf of the president. The president is acting for and on behalf of the Ghanaian people. And so the constitutional rationale was sound, that if the president is the trustee and you are going to grant lands in his name, which is why every public land is granted between the president of the republic and the lessee, we should have a mechanism where the president gives his imprimatur, gives his approval to the grant. So that is what was done. And that, I believe, the Executive Secretary of the Lands Commission and the Chair of the Lands Commission tells me that it's really helped in sanitizing the public land space. Because always remember that the Lands Commission is decentralized. So there could be, you could have land in, say, Nadilugu or Damangu or whatever, and it will be granted without even the knowledge of the Executive Secretary or the Chair of the Lands Commission. And when it becomes controversial, it is the president who gets criticized first of all, and then the minister, and then the chair and the Executive Lands Commission. But this one was really to clothe all of us authority to monitor how public lands are granted. And it is on that basis that I was, for example, able to reverse the grant of public lands in Tamale. If this directive had not been given in 2021, that could not have happened. The second one, which is a cabinet directive, that is directed at public institutions. What we observed was that public institutions were given land for particular purposes to help them to realize their core mandate or the purposes for which those institutions were established. But these public institutions then construe the land which has been given to them as their land, as in land that belongs to them. And therefore they go into all these public-private partnerships with private developers and say, this bungalow, we've given it to you through an MOU, build 10 houses, you give 6, give us 4. The president took the view, the president and his cabinet took the view that that is not a proper judicious use of public lands, and that did not serve the public interest. So this directive is to say that no public institution, as opposed to Lands Commission, can go into a public-private partnership without the prior written approval of the minister. So for example, if the Minister of Information wants to demolish this building and build a 20-story building, and they go into a PPP arrangement with a private developer, and the private developer says, we'll raise this building down, we'll build 20-story building, we'll give it 10-story, we will keep 10-story. The Minister of Information obviously will be better off with that kind of arrangement. But what we are saying is that for them to be able to do that, they need the approval of the president, because it's not all the time that those arrangements are in the public interest, and that is why I want to regulate them. So that's the distinction. Thank you very much.